Hello and welcome. I am Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today we are discussing the Companies Amendment Ordinance of 2018, which amends the Companies Act of 2013 to ensure better corporate compliance and reduce the caseload of courts. It also focuses on offences and penalties prescribed under the Companies Act, besides creating a civil liability regime to deal with technical and procedural defaults by companies. To discuss these issues, I have with me Mr. Ajay Brahme, corporate lawyer, and Mr. K.A. Badrinath, editor policy, Financial Chronicle. The Companies Amendment Ordinance increases the jurisdiction of regional directors. It is based on the suggestions made by the Injeti Srinivas Committee that reviewed offences under the Companies Act of 2013.
In July 2018, the Ministry of Corporate Affairs created a committee chaired by Injeti Srinivas to review offences under the Companies Act 2013. The committee was tasked with reviewing acts of companies that are punishable with fine or both with fine and imprisonment. It had to also recommend if such offences could be recategorized to attract civil liabilities. The committee submitted its report in August suggesting changes to the Companies Act of 2013. Since Parliament was not in session, the President promulgated the Companies Amendment Ordinance to make the changes to the Companies Act.
First of all, the issue of over-criminalization of non-compliances. It was increasingly being felt that even normal minor offences, minor non-compliances were qualifying as compoundable offences, which were making it very cumbersome for compliance to take place in an efficient way. The second major area was that the NCLT was getting overburdened. A recent report said that nearly the filings in NCLT were about to touch 10,000. So therefore the same pendencies that we were seeing prior to 2013 were again seeping in. NCLT proceedings were becoming slow. Therefore it was impacting all categories of cases. So the second challenge here is that a lot of cases, issues have been moved out of NCLT to the central government. So that's the second. The third is on the corporate governance front. There were some pain points which were required to be removed.
The Companies Act refers to offences that are punishable with fine, imprisonment, or fine, or both. Under the Act, the 7 regional directors appointed by the Centre and the National Company Law Tribunal have the power to deal with compoundable offences. There are currently 81 compoundable offences. The ordinance recategorizes 16 offences that are technical or procedural. These offences that were earlier dealt by the National Company Law Tribunal will now be dealt by regional directors. The ordinance also adds a new provision that doubles penalty for companies which repeatedly default on legal provisions.
The foremost feature or the foremost advantage which we'll have is like the declogging part. Because as you know that every day, like thousands of new companies are being registered in India, new startups are coming up. And the old act was creating a lot of problem with respect to, if you see, for example, if we have to convert a public company to a private company. So the previous act was not helpful in that part. Now with the new ordinance in action, it has specifically bifurcated that part and things are really smooth as of now. Now if you see as far as the pecuniary jurisdiction, if we talk about the regional directors as well, so earlier the pecuniary jurisdiction was fixed for 5 lakhs. Now with that increased to 25 lakhs. So now if people want to, were having, for example, if they've been fined around 10 lakhs, so the only option available to them was to go to NCLT. So now for even a small petty fine of 10 lakhs, they were going to NCLT, which resulted in multiple filing of petitions before NCLT and again, which eventually resulted in delay.
The regional directors currently have the power to deal with offences that carry fines up to 5 lakh rupees. Offences that carry fines above 5 lakh are dealt by National Company Law Tribunal. The ordinance specifies that regional directors can deal with cases where fines up to 25 lakhs are to be imposed. The ordinance shifts the power to approve alteration of financial years and conversion of public companies to private companies from National Company Law Tribunal to the central government.
The Companies Amendment Act, the ordinance focuses a lot on the recategorization of offences. And one of the things that it's doing is it is talking about compoundable offences. Can you walk our viewers through as to what is a compoundable offence under the Companies Act?
See, compoundable offence is one where although there is a penalty in case you have contravened the provision of Companies Act, So there is a penalty which the person who has contravened will be subjected to. But in case, see, the beauty of this amendment, I would say, is that there is a two-stage thing in this case. So one, you pay the penalty, and secondly, then you apply for something which has to be done in accordance with the law. Now that can be done concomitantly. So in this backdrop of the things, the compounding of offences, if any, that which has been done by somebody who has contravened it, it will be that you pay a particular penalty, and then it will be you will be dissolved of that liability. So that's what is the compounding in this case. Now that power has been the regional director, as has been explained just before a while in the program. So initially the regional director had the power to deal with the matters of up to 5 lakhs. Now it has increased to 25 lakhs. So even those offences or those matters which would have attracted a penalty until 25 lakhs, even those things can be compounded, and that too by before the regional director. So you won't really have to go to NCLT for this compounding of offences.
Okay, Mr. Badrinath, I want to come to you because I want to break it down further as to what is a regional director and what is the NCLT. But from what Ajay is saying, let me understand this. So what is now going to happen is that if a company has committed a default, or if a committee has transgressed any of the provisions of the Companies Act, it is required to either pay a fine or a penalty. Now that fine and penalty will be paid in front of a regional director, and they'll rectify simultaneously whatever they were supposed to rectify. Now, what are these regional directors, and what is the difference between regional director? How many of them are there? I think there are about 7 of them across the country. And what's the difference between the office of a regional director and the National Company Law Tribunal?
See, first thing about the compounding offences that we have been talking about, you pay a penalty, take a corrective measure, and then condone the offence. This seems to be the spirit with which the amendments have been proposed by the government, which will replace the ordinance which was promulgated by the President of India on, I think it was in November 8th or something. So the issue, then the Parliament was not in session. Now on Thursday, the Finance Minister introduced the bill which will replace the ordinance. This is the first part. Second is, when it comes to the offences as such and the penalties that have been proposed, is that it's like, more or less mostly in sync with your European laws or the US laws. It's the best practices that are there globally. And there also the same way that if your offence has been done, you have to, pay a penalty and then get over it. Second, the issue here is that you want about the regional, because India is more or less like an European Union, you say. You have 29 states and 5 union territories. So it's huge. The number of corporate entities is also very huge. Small, micro, medium, large, very large entities and all that. So the burden on the central office of the Company Law Board is huge. So henceforth, the regional directors should be empowered more. In fact, even the 25 lakhs that we are talking about in the bill is much smaller amount. Here we are talking about crores of rupees. So my guess is at least the limit should have been at least 2 crores. So that more and more cases get devolved towards the different regions from where they are registered or where their offices of operation are there. And secondly, the issue, it's not practically possible or logistically possible for one central office to deal with all the offences, all the cases, and the kind of pendency that is there at the central level, so huge that it cannot be possible.
Correct. So Ajay, coming to you. So the Companies Act is a central act. The Companies Act has ensured that throughout the country there are northern officers, eastern officers, southern officers, and these are the offices of the registrars. Now, what does it mean that, what kind of offences are these, the ones which are compoundable? I'm assuming if you are just able to give a fine and get away with it, these would not be of too much of a serious nature. These must be of either a technical nature
Yes.
or of more of a filing requirement that you haven't submitted a document that was supposed to be submitted. Can you shed some light on that?
That's correct. In fact, I think the question, or if I could actually give you the genesis or the meaning of what is compounding, possibly then the entire scheme and purpose of the act would be explained. See, as Sir has rightly explained, that it has been adopted from European and US practice. So actually the practice over there is, they call it plea bargaining. In case it's a criminal, it's an offense under Criminal Act. So there you actually say that, I'll pay an X amount depending upon the case, and that I'll pay an X amount, you please reduce the sentence or just quash the entire proceeding against me. So that's what happens. I mean, it is the principle remains same. That's what happens in the compounding cases also. So under the law, compounding it's only those offences which are like either small matters or which doesn't really attract those kind of severe offences. It's like, in case it's a fraud, then possibly it cannot be compounded.
Correct.
For fraud, then 441 provisions, that section
Applies.
441 would apply. But in case it's a mere omission, not a deliberate omission, because and then in case you have not done it second time, then those kind of offences, but still it's an offence because obviously there has been a dereliction of duty on your part. So then these kind of provisions can be, these kind of offences can be compounded.
Okay.
See, I'll give you one example in the case that Ajay was talking about, in the sense that, say for example, under the company's law, if I'm, please correct me, that a director can be on the board of, I think, 4 or 5 companies, and there is a limit.
20.
And where you can,
20.
20. So if you, or say for example, you go beyond your limit, say 20 to 22, you don't make it a criminal offense. So that's the issue.
Okay. Great. So, but it's time for us to head into a break. When we return, we will discuss the ordinance provisions that enable better compliance of the law by companies. Welcome back. We are discussing the Companies Amendment Ordinance of 2018. In addition to the provisions related to recategorization offences, the ordinance has provisions to enable better compliance of the law. It reintroduces the requirement for companies to provide a declaration before commencing business and provides for deregistration of companies that don't maintain a registered office.
The Companies Amendment Ordinance specifies that within 6 months of a company being incorporated, its director have to declare that every subscriber has paid up the value of shares. It has to also file for verification of its registered office. These provisions provide an early warning against companies that have negligible business operations and are often used for illegal purposes. They also give the registrar of companies the power to physically verify the registered offices of any company. Violation of these provisions has been made grounds for deregistration of a company.
The role of director has increased. They have been given ample power to compound the offences. And while compounding the offences, they will go on one format only. You see, the role of bureaucracy has increased. The bureaucrats never apply judicial mind. Here the companies will suffer. This power should not have been given to regional directors.
The Companies Amendment Ordinance also lays down stringent penalties for not declaring a beneficial interest in a company. People holding beneficial interest of at least 25% shares or who exercise significant influence or control over the company are required to make a declaration of their interest. Failure to declare this interest is punishable with a fine between 1 lakh rupee and 10 lakh rupees. The ordinance enhances this penalty by providing that failure to declare such interest would also result in imprisonment for up to 1 year in addition to the fine. Also, if an individual is a director in more than 20 companies, it will be a ground for disqualification from directorship.
A whole load of these non-compliances, which were earlier kept in the basket of compoundable offences, therefore being criminal offences in that sense, have now been shifted to the category where they are seen as civil liabilities. In the earlier case, a fine following a compoundable offence could be imposed only by a court. So therefore a defaulter had to be first prosecuted. A court would have to come to a finding that indeed he has committed a wrong and then impose a fine. So on one hand, it delays the whole process of compliance. If somebody fails to do something, the prosecution can take years, and therefore the non-compliance can continue for years, which has been the very root of our problem in India with respect to compliance. By putting it in the category of civil liabilities, it is now for the central government through the regional director to impose penalties. Therefore, it can be done much faster, much swifter, and non-compliance can be checked, and action can be taken to ensure that compliance is done on a far more fast-track basis. So this is a huge improvement.
The Companies Act of 2013 allows companies time up to 10 months to inform the registrar of companies about the charge made on their assets. The ordinance reduces this period to 2 months and provides that any extension can only be made on payment of an ad valorem fees. It also specifies that if people willfully provide incorrect information, they'll be prosecuted for fraud under the Companies Act.
An additional provision that the Companies Amendment Ordinance is making is it's penalizing repeat offences. So if a company has committed an offence or committed a transgression on multiple occasions, there's going to be a higher penalty for that. And Mr. Badrinath, let me begin the second part of the show with you. There was, in the 1956 Companies Act, there was a requirement to give a declaration before commencement of business. That requirement was removed in 2013 Act. The idea being that it should be easier for companies to start business. The requirement for making the declaration is now coming back again through this ordinance. What is the rationale for that?
See, the point here is that one, the new provision makes it simpler. And second issue here is that, say for example, you want to re-register yourself when you have deregistered and then you want to get back to business, then it was to take a lot of time. Now the amount of time that is taken to re-register is easier. Second. Third is that when you have decriminalized many of the offences that we talked about in the first part. Now the issue here is that what is the kind of do's and don'ts that you do in terms of when you get back to business is an issue which also is part of the the bill that has been brought in right now by the finance minister.
Okay. Ajay, one of the things, that the government's press release said was part of bringing around this declaration before commencement of business is to check companies that just get registered and do not, conduct any business. And, sometimes they are referred to as shell companies. Can you shed a little bit of light on that?
See, there are 3 provisions related to this. One is section 10, another is section 12, which has been, the changes that have been brought in this ordinance. Before this also there was an amendment in January 2018. So section 89 and 90. So there it mandates that you need to give declaration A. Secondly, as per section 12, the ROC can actually go and physically inspect the premises, whether the name is there, name of the company is there,
whether
or not.
Any actual business is
happening. Now the rationale is that there used to be several shell companies which people would float under the name of, let's say, their drivers and these people also, and they may or may not be actually conducting any business, but it would be although the people call it an SPV, that is special purpose vehicle, but it is actually a shell company which is doing no business, but the money is being routed through this company. So in order to check some such I would say conduct of the people, which is of the business entities, which is actually just to bring their black money into the mainstream. So to check these things and bring transparency into the economy, I think these amendments have been brought in.
Okay.
See, in this case, if I can allow to add something, This practice, if you recall, Ajay, is mostly prevalent in tax havens like Mauritius and elsewhere, where they are called as the post box companies.
A company basically on paper.
There's a paper and post box companies which are normally used for making a lot of financial transactions across the borders. This was the case. Secondly, in the recent campaign against black money, there has been a lot of data that has been mined, and which says that in one particular address you have more than 436 companies operating. So these are certain practices which needs to be curbed.
Okay. So now what the ordinance, and Ajay, you can correct me here, now the ordinance is doing is that the registrar of companies can physically go to an address and verify as to whether the company is functioning there or not.
Yes.
And in case it's not functioning there, this can be a ground for deregistering the company from the role of the registrar of companies.
And it may as well be an offense.
Okay.
Because then certainly you have done something, which is a fraudulent act. So even 441 may be attracted.
Okay, great.
And also that if there are any possible malpractices that are there found on the premises, that could be a ground for you to deregister or not recognize your business or stop you from operating.
Yes.
Excellent. And I think there is another provision which allows directors to be disqualified. So I think one of the provisions that we were discussing in the previous part of the program is the ordinance now says that if you are a director in more than 20 companies, now that will be a ground for disqualification, from directorship.
Yes.
But Ajay, let me come to you. There is this provision around registration of charges. Can you explain very briefly as to what a registration of a charge is and what is the change that the ordinance is bringing?
See, a business is run by taking some loans from a financial institution. So you would mortgage some security interest. Let's say the land that you mortgage with the bank, although that land may be the property of the company. So a charge would be created of that secured creditor being this financial institution. So you need to register that charge. Now the rationale why it is required is, in case you have created a charge on a particular property and then surreptitiously or maybe fraudulently you try to further sell it off or create some loan over it or money fund over
the
it.
Same thing with multiple people.
So this is that shell company thing, in case you need to understand it in the broader perspective.
No. The best example in this case is that of Satyam.
Yes.
The Satyam Computers case, if you recall that case, Ramalinga Raju's case, there are several properties where it was, mortgaged. The same, property has been mortgaged to multiple creditors.
Okay. And Badrinath said, so the idea is when you register a charge, it becomes public information. Anybody can see.
Of course, it comes into the public domain.
Other financial institutions can see as to whether the charge is registered or not, and then decide as to whether they want to levy. So what does this reduction of time do? Does it enable better compliance?
Yeah, definitely. In the sense that, if you reduce the time limit, the compliance layer, the compliance will automatically increase, the processes will be simpler, and it will also maybe to an extent add to the ease of doing business.
Okay, great. That's all the time that we have in the show today. Thank you, Ajay and Mr. Badrinath, for joining us on this discussion. It is time for us to end the show. You can watch our shows on the RSTV page on YouTube. We will be back with a new episode and a new issue. Keep watching Rajya Sabha TV.